The contempt now purges his contempt by retracting the scandalous statement on the very same medium.
That and more tonight on Top Story, made possible by Vodafone. The future is exciting. Ready? Gasm, the nation building, Bill Aquaman. And there's been a total of 6 court applications filed by 2020 NDC presidential candidate John Dramani Mahama, demanding answers from EC chairperson Jean Mensah on how she supervised the conduct and declaration of the 2020 elections. Now, all 6 processes were shut down by the justices of the Supreme Court, 3 times as a 9-0 decision, and the other 3 as 7-0. The 6th was dealt with this afternoon as lead counsel for Mr. Mahama fell on scripture in a push to have the Supreme Court set aside its earlier decision not to allow a reopening of the petitioner's case. Listen.
As Aqua indicated in the Kublex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated on oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind, and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear.
Sowing the wind and reaping the whirlwind, the final push by Tetuti Kata, but the decision of the court being supreme. But our court correspondent, Joseph Akable, joins me with more on today's proceedings. Now, Joseph, this push by Tetuti Kata was opposed by the EC and President Akufo-Addo's lawyers. What did they have to say about the push with the scripture?
And so first, Justin Amenuvo, who represents the Electoral Commission, was the first to speak. He told the court that when the court was ruling on the request for the case to be reopened, the ratio of that decision, i.e. what the court relied upon to conclude, was to answer the question as to whether or not Mr. Mahama's lawyers have demonstrated any evidence that they intend to obtain from the EC chairperson. That evidence should be of the nature that once the court admits it, it has the potential to materially affect the outcome of the case. And so he said that that was how the court concluded. And so the references that they had made to various provisions that Mr. Chikata took the view that the court had wrongly interpreted, he said those were not the basis for the court's earlier decision. Mr. Kotampao made a point that the court has, Mr. Chikata has woefully failed to satisfy the conditions for a grant of a review. And he stated the conditions as follows. 1, there has to be exceptional circumstances which have resulted in a miscarriage of justice. And number 2, a discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not be produced by him at the time the decision was given.
Well, on the specific case about the scripture, for instance, we heard one of the lawyers mention that God is a God of conscience. But what then was the decision of the court?
The court made a point that its review jurisdiction is of a special nature. It's not an avenue that lawyers who are dissatisfied with a court's decision come in and now use it to re-argue a matter that has already been decided. The court made a point that in order to meet that requirement, you need to satisfy the court that exceptional circumstances have resulted in a miscarriage of justice. We can listen to excerpts of the decision read by Chief Justice Kwesi Eniebwa.
It is important that this court should set its face against such endeavor in order to protect the integrity of the review process. This court has retreated several times without number that the review jurisdiction of this court is not an appellate jurisdiction, but a special one. Accordingly, an issue of law that has been canvassed before a bench of 5 and on which the court has made a determination cannot be revisited in the review application simply because the losing party does not agree with the determination. This, unfortunately, is the substance that the current application before this court is. End of quote. The application and the review was dismissed because it was not based on any known law or rules of practice. We dismiss the instant application as being wholly without merit.
The decision of the court was put out by Chief Justice Ening Yeboah. Now, Joseph, you've been tracking all the court's decisions from day one. How many major requests have been made and how has the court ruled? I'm interested.
And so the 7 justices and at times 9 judges hearing the 2020 election petition have been called upon on 11 occasions to rule on various issues. And these are mainly matters that have seen lawyers representing the respondents, i.e. the EC and President Akufo-Addo, take positions contrary to the position of the petitioner, John Dramani Mahama. And so the 7 judges, we know them. There's Chief Justice Kwesi Ening-Yeboah, there's Justices Yawa Pearl Mafusau, Nena Megacha, Professor Kote, Mariam Owusu, and Gertrude Tokonu. On 3 occasions, they've been joined by Justice Amadou Tanko, while on 2 occasions, they've had Professor Henrietta Mensah Bonsu join. Then on 1 occasion, we had Justice Lovelace Johnson joining Justice Tanko on the case. The ruling so far, so first, it unanimously granted the petitioner's request to amend the petition, i.e. correct minor mistakes that did not affect the substance of the petition. Secondly, it unanimously dismissed a request for interrogatories to be served. These were the 12 questions that they wanted the EC chairperson to answer. The third issue they dealt with when they were constituted as a 9-member panel was to unanimously dismiss a request to substitute a paragraph and add additional ground in a push by the petitioner to have the interrogatories ruling reviewed. The fourth one had to do with a 9-member panel also unanimously dismissing the review of interrogatories ruling itself. The ordinary 7-member panel by unanimous decision struck out portions of petitioner's witness Johnson Esiodin Nketiah's statement. Specifically, they struck out 7 paragraphs while maintaining 3. This panel also unanimously dismissed the request by the petitioner for documents to be inspected. The panel unanimously struck out 5 parts of 32 paragraphs of the petitioner's witness statement, i.e. Metu Nunu in that instance. Then the panel unanimously rejected the petitioner's request to compel the EC to call Jane Mensah to testify. Number 9, the panel unanimously dismissed the petitioner's request to reopen his case. And number 10, the enhanced 9-member panel dismissed the petitioner's request that it reviews its decision not to compel Jane Mensah to testify. The 11th, which took place today, an enhanced 9-member panel dismissed the request that it reviews its decision not to allow the petitioner reopen his case. We've heard a lot of unanimous and a lot of dismiss. So we did the math. It can be seen from the above that it is only on 1 occasion that a request by the petitioner has been wholly granted. This was the request to correct the mistakes, which was the first thing that the court dealt with. The petitioner's viewpoint has been partly upheld on 2 occasions. When it came to striking out portions of the witness statement, some portions were maintained, and so the court granted it partly while they upheld that of the respondent. And so that happened twice. And the other one that we need to note is that the legal arguments of the respondents have swayed the court and the justice for that matter on 8 occasions.
Okay, so there was a pleading today also in terms of the final address. There was a decision by the court on that.
Yes, and so a request was made that they wanted some more time to file that particular process. It was opposed by Mr. Kotampao. He specifically said that because an order of the court had not been obeyed until the court is an apology is rendered to the court and it is created or stated in clear terms that the request is being made because they had disobeyed the court previously, then the court should go ahead and grant the request. Mr. Menuvo opposed it and said that CI 99 permits the court to strike out a petition entirely if you disobey the court order. But the court granted the request, and the directive that it gave was that tomorrow, by close of day tomorrow, they should file the written addresses for the petitioner. And so that is where that leaves us. And so we've had the respondents file their written addresses. Then the petitioner is to file that by close of day tomorrow with the date fixed next week, Thursday, March 4, for judgment.
And that's the judgment day as far as the election petition hearing is concerned. Now, one major issue also occurred today whilst we were in court. The court dealt with an issue of contempt involving former Deputy Attorney General Dr. Dominic Ayene, who is also a member of the legal team of the petitioner. Walk us through it.
And so the court on its own cited him for contempt, and the court, it had to do with the press briefings that are done after proceedings. And in one of such press briefings, he had made some comments that had the word predetermined in there somewhere, and the court took the view that the comments that were made were scandalous to the court, and so they summoned him over to come and show cause why he should not be punished for contempt.
This is the order of the court. We accept the apology of learned counsel for the contempt. No. We, however, order that the contemnor purges his contempt by retracting the scandalous statement on the very same medium before Thursday, the 25th of February 2021, when the court will reconvene. The contempt proceedings is thus adjourned to Thursday, the 25th February 2021 at 9:30 a.m. So, Mr. Bicham, so you will come here 9:30. If he renders the apology, we will come and completely vacate the order.
So, Joseph, even before the court's order for an apology or purging himself of the contempt, we know that Dr. Ayine and his lawyers apologized before the judges in court.
Yes, he was represented by a former president of the Ghana Bar Association, Frank Beecham. In open court, he quickly informed the panel of judges that when he also heard about what Dr. Ayine said, he took the view that it was indeed scandalous and did have engagement with him and also indicated to him that they should take steps to apologize, and that's how come he actually wrote to the Supreme Court.
My Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis, and Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter this morning to the Registrar of the Supreme Court to bring it to Your Lordship's attention.
So we have copies of the letter, and we've circulated it. Yes, we are comfortable with the apology, but we want to make certain consequential of this. Yes, Mr. Bicham. Yes, you can be heard.
Yes, my Lord. With respect, our client has no excuse. Personally, as lead counsel for him, I was very disappointed at the article that I read last week and was deeply distressed when he called me last night. And I thought it was because I had made certain disparaging remarks expecting some action to stop this canker in the profession. It was to tell me that he had realized the error of his ways and pleaded for me to join him to render an unqualified apology to this court. He makes no excuses for that. He admits he is wrong and has been wrong. He deeply regrets the harm done to his profession, the disrespect shown to the court and to also to the country. I have his instructions to render his unqualified apology to every member of the Supreme Court and indeed the judiciary of Ghana and to the legal profession and people of Ghana that he's awfully sorry for what he has done. He is deeply remorseful and he deeply regrets what he's done. So, my Lord, our prayer is, yes, true justice has to be done, but we ask you to temper justice with mercy.
So that's the apology that was offered by Dr. Ayine's lawyers while in court. But just so we're clear, Mr. Chikata did not stay for this part of the proceedings?
In fact, after the CJ had announced that they are adjourning proceedings to 4th March, the court clerk called the case for this particular contempt. And once he announced it, Mr. Chikata stood up and asked the judge, the Chief Justice, that just to be clear, the petition has been adjourned. Then the CJ said, yes, this is a contempt issue they're coming to deal with. He packed his books and he walked out of the courtroom.
Interesting. But some of the judges had some concerns.
Yes, another former president of the Ghana Bar Association, Justice Nene Amegacha and Justice Emefa Apawu, took strong exceptions to the comment that were made by Dr. Ayine. They said as a respected member of the bar, they didn't expect him to make such comments.
I have been worried for some time now, listening to people granting interviews to the media, and not any ordinary people or lawyers, but people who have occupied very high position in this country. And we have to decide where we want to go as a country. In my view, the only reason why Article 88 of the Constitution, or the only ministerial position which is provided for in the Constitution, is that of the Attorney General, is that when you are appointed an Attorney General, you are appointed an Attorney General for the whole country. A party or a president may appoint you as Attorney General, but once appointed, you are the Attorney General for the whole country. And you are to ensure that every citizen of the country is given justice or has access to justice and fair trial. So when I hear former Attorney Generals and Deputy Attorney Generals mount or grant interview and make certain statements, aligning in no uncertain terms to one political party, it's something that worries me.
I know he's a member of parliament and therefore a politician, but he should know how to talk when he's addressing the press as a lawyer, and then how to talk when he's addressing the press as a politician. There are two different things, because I know when politicians mount the witness box, they say anything, they can say anything at all. Then at the end of the day, when they are recorded, they come to deny. I've been a politician before. I know how it is. So you should know how to talk as a politician and then how to talk as a lawyer. They are different things altogether. It's like we've been insulted, judges are insulted by people who know nothing about the law, and sometimes who know nothing about the issue that is before the judge. And they talk and insult. If they are not lawyers, we don't care. Because if you don't want to be insulted, you cannot be a judge. But if you are a lawyer and who knows the law and who knows the procedure, and then you talk, in a manner, that does not speak well of you as a lawyer, it gives opportunity to non-lawyers to also talk or say worse things.
So you heard there earlier, Justice Amegache and then Justice Yawapo, the admonishment to Dr. Dominic Ayine. Now, what form did the out-of-court apology take? We understand he was flanked by lawyers from the opposing side whilst he did so.
Yes, and you recall the directive was that he uses the same medium. And so in terms of those who joined him render that apology, there was Frank Davis, who is one of President Akufo-Addo's lawyers. You recall Dr. Ayine indicated in court that it was actually Mr. Davis who approached him and informed him that the comments he had made were not in the right direction, and so he should think about it and take the right steps. There was also Agabi Asare-Otredako. We know him, West African Legal Associates, and works closely with the President Akufo-Addo's legal team as well. So they were with him as he gave this address at the same medium that he had used to make the earlier comments.
And you're welcome back. This is The Pulse with me, Gifty Ando Apia. We'll be going through our stories shortly. We're taking a look at the coronavirus. We're taking a look at the expected vaccination. But we need to go to the courts right now and hear the other side.
Of February 2021, I addressed a press call at the premises of the Supreme Court in respect of a ruling that the court had rendered on that day. I did so in my capacity as a member of the legal team of the petitioner, with instructions to brief the press on matters of concern to the petitioner after court proceedings. In carrying out my instructions on previous occasions, I had always made certain that I explained the day's proceedings to the understanding of the press corps and of fellow citizens with civility, and without seeking to attribute acts of impropriety to the Supreme Court or the respondents. On the said day, I thought I had maintained that approach to the press briefing, but on hindsight, I actually crossed the line in suggesting that the court had a predetermined agenda, among others, to rule against the petitioner. My attention was drawn to this fact immediately after the press briefing by Frank Davis, Esquire, to whom I am grateful. It was not my intention to scandalize the court or to bring it into disrepute. In the circumstances, I wish to apologize unreservedly to the court. Yours sincerely, Dr. Dominic Akuruting Ayine, signed. And for those of you, I'm sure Mr. Frank Davis is not a stranger to the press. He's standing here to my right. I remember on the 16th of February when I finished addressing the press, he walked up to me and reminded me that the phrase that I had used, that there was a predetermined agenda, had crossed the line. And that is when I started thinking about whether or not I had crossed the line. And I agree absolutely with Mr. Frank Davis and those of you who think that I crossed the line on that day. I wish to unreservedly apologize to the court, that is the Supreme Court of the Republic of Ghana, as well as the justices in particular who sat on that day. There was no intention on my part to impugn their integrity. I was just expressing a sentiment with respect to the ruling of that day. And I want to render an unqualified apology and to retract the words that I used on that day in their entirety.
So you have the former Deputy Attorney General and a member of the petitioner's legal team, Dr. Dominic Ayene there, offering that formal apology. That's the medium in which he made that predetermined statement earlier. So he was supposed to use the same medium to apologize to the court or else risk being punished. And the court will hear this case on the 4th of March, the same day for the judgment of the petition. But I would want to find out what then happens on the 4th when the court resumes, the 4th of March. No?
And so
Okay.
First, the court is coming back on Thursday.
Exactly.
And so the Thursday it will come to a conclusion as to whether or not this comments that he made has purged him of the contempt. And so if the court is satisfied, the court says to strike out the process. But if not, then it will impose sanctions. And it's important to note again that, on that particular platform, when he comes to address, he mostly takes questions from the press. This time around, when he finished, he actually said that, look, I'm not taking any questions on this issue. And he actually also emphasized the fact that in apologizing or retracting, he is mindful of the potential of saying something that will negate the actual thing that he intends to put across. And
which
so
he described as a constipation, sort of.
Exactly.
But what really was the mood? It's interesting that he was flanked by members of the second respondent's legal team. Let's talk about the mood during when he was, delivering that apology to the court.
So first, I'll start from when I got to the court this morning. Actually, I met Dr. Ayene at the car park. It was very unusual in the sense that mostly he comes during proceedings. And so when I saw him around 8 a.m. at the court premises, I was wondering what was happening. When he came into the courtroom, he went in to greet his colleagues there. During the recess, he crossed over and was interacting with Mr. Emefa Apawu and the other lawyers, among other things. So it was at that moment that we had gotten wind of the fact that the contempt proceedings will be dealt with by the courts today. And so we understand there was some attempts to ensure that everyone is on the same side, and if there is the need for anyone to come in to assist, that would also be carried out. That is the information that we picked up. And so he was calm. He was his normal Dr. Ayene. And this is not the first time that the judges have engaged him. You recall there was one occasion during proceedings where he had made some gestures that the CJ was not excited about, and he called him up and spoke to him about that as well. And so that is by way of how things were. He was calm. Even after proceedings, he walked to some of us and was still telling us that we shouldn't ask him any questions and we should allow him to go.
Speak about it. But earlier in court, though, Mr. Frank Davis had cause to raise some questions or issues about an example that the Chief Justice made, citing him.
Yes, when the CJ was talking about the fact that in the past they had made reference to Dr. Ayene, he again said that indeed they had made reference to Frank Davis and Mr. Yaopon and Marita Briapiopon, but those two related to the fact that they are lawyers on record, i.e. Mr. Yaopon and Frank Davis, lawyers on record who are representing a client who are granting interviews contrary to the Legal Professions Act. And so that was in the context that the CJ had made a reference, but Mr. Davis stood up to point out that he wanted it to be clear that he had not made any comments that the court considered to be a contempt of court crime to say, so that requires him to now come and defend himself. And so he just wanted that to be stated clearly.
Well, so let's talk about the 4th of March, the judgment day proper. So this one will be heard on Thursday, this very Thursday. But the judgment day is on the 4th of March, which is for the election petition itself. Let's talk about what exactly is suspected to happen on that day.
And so a decision will be given by the 7 judges. It will answer 5 questions, and it's important to remind ourselves of those 5 questions. So 1, whether or not the petition discloses any reasonable course of action. Number 2, whether or not, based on the data contained in the declaration of the first respondent and second respondent as president-elect, no candidate obtained more than 50% of the valid vote cast as required by Article 63.3 of the 1992 Constitution. Number 3, whether or not the second respondent still met the Article 63.3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techiman South constituency presidential results. Number 4, whether or not the declaration by the first respondent dated 9th of December 2020 of the results of the presidential election conducted on the 7th December 2020 was in violation of Article 63.3 of the 1992 Constitution. And finally, whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential results of 2020. And Article 63.3 simply says, in order to win the election, you have to get more than 50% of the votes cast. And so these are the 5 questions that they would answer, and by answering these 5 questions, we will know whether the declaration of the results as done by the EC chairperson will be affirmed or set aside. And mind you, the petitioner is asking that they should hold that no one got that and call for a rerun, specifically a runoff between Nana Danko Akufo-Addo of the NPP and John Dramani Mahama of the NDC.
Well, Joseph Akable, we'll see you again on Thursday, and then hopefully also on the 4th of March, Judgment Day. Thank you so much, Joseph Akable. And final argument, we're hoping that will be filed by the petitioner by close of day tomorrow. Be monitoring that as well. And as and when we get it, Joseph Akable, our court correspondent, will bring you all the details. That's it for Top Story, brought to you by Vodafone. The future is exciting. Ready? Gasm is the nation builder, and Bell Aqua Mineral Water. You must drink water. It ought to be Bell Aqua Mineral Water. I'll be right back with Newsnight.
55, 78, 58, 70. Hey, Charlie.